Spence's comment? Yes, thank you. What Mr. Spence read is an accurate reading of the eligibility recommendation and what's known as the PLAF statement. That's a mouthful, present level of academic achievement, function, and performance, I believe. And that is that what he read out of a 21-page report is verbatim from the school psychologist's 8-page report that also makes the point that medical documentation on ADHD has not been obtained. That is a critical factor for eligibility for ADHD. ADHD is a medical diagnosis. There is testing, such as the Connors test that's referenced in the report. There's anecdotal information from parents, from teachers, from the student himself, from looking at behaviors such as have been shared that would suggest, as the PLAF statement does state, that it is suggestive of behaviors associated with ADHD. Kind of like clue, but for eligibility under the law for ADHD, as well as under Section 504, you have to have a medical diagnosis. The school district cannot obtain that on behalf of the student. That is something that the parent must provide to the school district. And so I think that the psychologist in this very detailed report is making the point, and it shows up in the psychologist's report as well as in the PLAF statement, that here are some signals that concern us. But by law, and I am inserting the word by law, the psychologist didn't, they can't reach that conclusion without the medical documentation. And they said, if it is provided, we should revisit that. That is, in my legal opinion, an appropriate statement. It is being honest and genuine with the data and information that is being provided to this MET team. They didn't ignore it. They didn't flush it off to the side. It was in the psychologist's report, and it wasn't buried in the report. It was put in the PLAF statement. But they also couldn't find eligibility. All 4 of them checked the MET form that said not eligible under what's known as OHI, which is the ADHD eligibility factor, because there's not a medical documentation. So I, as a matter of law, am not troubled by that. The manifestation determination review team could not look at that because there's no medical documentation of that diagnosis.
Wasn't it said earlier that in fact he was at some point in his academic career diagnosed with ADHD?
3rd grade.
In the 3rd grade? So at one point he was. But at some point it expired, for lack of a better term, or was removed?
The parent requested, there's documentation in the record that the parent requested no further eligibility under special education, and by law, that parent wish must be respected. The school cannot force it.
And so then how did we come in 2014 to have the diagnosis for disability for math? How did that come?
Because it's not a diagnosis. A learning disability, unlike ADHD, is not a medical piece.
Okay.
And this, I presume that the parent signed an evaluation because this could not take place without parent authorization.
And so that's why I'm asking the question. If it took place for purposes of math, given the history and the behavior, I'm wondering why he wasn't reevaluated for other
They did. They evaluated him specifically
But there was
for
no
ADHD.
medical documentation.
That is not the school's responsibility. We do not send children to medical doctors.
That is fact. So in other instances where kids demonstrate behavior where ADHD may be apparent and present, how does the parent come to know that and know to take the child for an evaluation? I understand the school plays no part in the role, but does the school, do the school and the parent, this is a child, and the parent and the school district are to work together. If the school district suspects an issue and a problem, and there's no communication with the parent, how are the child's shortcomings begun to be addressed? Do you understand what my question is? Clearly, it's and what's in the report kind of supports my line of questioning earlier based on the behavior that I see here, and that nothing happened but the behavior continued. There was no other outcome that we could have expected but the one that we're here for today.
I disagree with your conclusion that nothing happened. This school district took significant efforts.
Nothing, let me qualify my statement further, Ms. Swim. Nothing happened with regard to further evaluation medically of this young man to determine whether or not he had any emotional disabilities. Having said that, what is an appropriate consequence? We're to answer that question. What are we to base that question on?
The conduct. The code of conduct and the student's behavior. The special education issues are solely dependent on the IEP team and the special education law process. Again, with all due respect, that is not the province of the Board of Education. So, in summarizing my response to your question, if you find the conduct occurred factually, and then you must determine what is the appropriate consequence. You've heard the recommendation from your administrative team, and you look at the record, because it's also alleged persistent disobedience and pattern of misconduct. You look at the conduct that occurred on May 22nd and draw your conclusions.
Only the conduct that occurred on May 22nd?
No, and the allegation is also for persistent disobedience and pattern of misconduct, and that's outlined in specific terms in Mrs. Cermak's letter, where she identifies additional conduct of a similar nature.
Mr. Sharp, are you ready to hear from family, the students' representatives?
I am, Madam Chair, to the
Are
rest
we
of
all
the
ready
board.
to move on?
Great, and I appreciate the patience and the time you've expended with the administration position, and I hope I can also have some of that time. When this case first came to me, I wondered why Okemos Schools was going to put an expulsion on the record of this young man. We heard the principal talk about her rationale that for the protection of the students and the safety, and they didn't want to work with him. Why would she say that when she already knows he's moved out of the district, has no intentions of coming back? That this expulsion that you are now contemplating is going to keep him out of school in hope where they're ready to admit him for 6 months to a year. Why would you do that? It's not for the benefit of Okemos Public Schools. It's punitive, it's vindictive, it's thoughtless. And the reason I said it that way is because you see this problem time and time again, particularly when you're dealing with kids with special needs, when you're dealing with kids who are of color, of lower social economic class. They get stigmatized, people speculate, and then they send them down the river because they are expendable. I told you I was the ACLU. I'm not here representing them, but it is a known problem that kids, especially kids of color, are being subjected to discipline much more aggressively than other kids who are quote normal. One of the things that I left on your table is the fact that as of last week, the State Board of Education adopted a guideline saying you're doing this much too aggressively generally throughout the state. You're causing us problems with the feds. The feds have put together guidelines saying you're suspending people needlessly, you're ruining their lives. So you've got this guideline. The action that you're talking about now, totally outside the guideline. This kid could come back to Okemos if he had a behavioral plan. But he chose, his parent chose, to just take him somewhere where he was welcome and they're willing to work with him. So if that's the case, why are we wasting our time while you try to suspend him and then expel him? What do you accomplish other than ruining his life or making it worse? That's the first issue. You know, I'm trying to understand why they do this. We already touched on the fact that we're dealing here with a kid with special needs behavior, so I'm not going to expound on that at this point. Because this originated as a special ed type of situation leading to that manifestation here and so forth, you know, and I may be wrong, I don't practice this area of law, but I believe that at some point the parent has to be offered an opportunity to agree or reject the proposal, and there's supposed to be a signature.
There's no longer a signature requirement. That rule changed a few years ago.
Right. But in any case, you're asserting as facts things that my client doesn't even agree with. And we'll find out more about it. You know, like I said, I'm somewhat disappointed because we have here people giving you hearsay what they think, what they speculate, what they believe that Ms. Holmes said or meant. This occurred in third hour. You know, I just got the email today. Fine. The kid was allowed to stay in school through 3 other classes until 6, and only after he left was he notified that he was suspended and going to be expelled. If he was that dangerous, that much of a threat, why are you leaving there for the rest of the school day? Inconsistent with the logic and the position you're taking. Timothy has his problems and issues. And when we go through, I'm going to talk to the 2 witnesses here I'm going to call. You know, they say he was threatening. It's not even obvious that he was threatening. That's a subjective standard. You're dealing here with a kid that's used to talking a certain way. You know, I'm going to jack you up. I'm going to make you sorry, stuff like that. Is that a threat? Well, from his perspective, it wasn't meant as a threat. Even one of the instances where you cite, you threatened, somebody said, oh, I didn't mean that as a threat. But you take it as a threat because you're intimidated by his language. The other kids talk that way. You know, so what's going on here with it so special with this kid when he makes some statement like that? He has goals, he has aspirations, he's making progress. He finally got into an adult, I mean not an adult, but a special education program that is showing progress. He's not the best student, but he's trying. When you look at that guideline, when you look at this school to prison pipeline that we talk about, where people get kicked out of school and where do they end up in prison? Why are you kicking out a kid for something like this? Do you think he's going to be disruptive of the school more than he's been in the past, more than other kids? You just are not ready to deal with it. So he wants to leave. Let him leave and go someplace where he can be better received and have another chance. Don't punish him by keeping him out of school for a year anywhere else. And you all know he's not even a candidate for schools of choice because he's been suspended. So he's going to be going where he resides, in Hope. Are you wasting taxpayer money? Only if, no, but you're only not if you're trying to protect Hope. And Hope Public Schools can take care of themselves. And hopefully Tim can.
Excuse me, Mr. Spence?
I didn't interrupt you.
No, that is very fair. I'm just wondering, sir, if I could have 2 minutes of your time out in the hall.
Yes, I'd love to talk with you.
Thank you.
If it's okay with the chair.
Yes. Thank you.
Sorry.
that happen without your participation, Madam Chair? That's called sidebar. Don't just see the file here.
There's some representatives from both sides of the